So yes, the other day we were discussing about the three different kinds of equity jurisdiction. The first kind was exclusive jurisdiction. So these are those matters in which no right was recognized under the common law, and this right was specifically or exclusively recognized by the court of equity. Now it has become a specific equity right. Okay, earlier it would have been recognized by the chancellor as a matter of conscience, and the new right is recognized, and then you are also provided remedy accordingly. And because these rights are available to you only under equity, so all these matters come under exclusive equity jurisdiction. Okay, the second kind is concurrent equity jurisdiction. Okay, why is it concurrent? Because unlike the previous case, in the second types of cases, uh, the right is already recognized under the common law. Okay, the right, you are also provided remedy. Okay, but the remedies are not, satisfactory. So the same right is also recognized by the court of equity or the court under the equity jurisdiction, and it provides you certain additional remedies. Okay, so we discussed some of them. So for example, injunction, and then you have specific performance. Uh, all those come under this second category. Okay, so we also discussed that the remedy under this kind of jurisdiction will be available to you only if the right is also recognized by the common law. Okay, under the common law. Okay, if no such right was recognized under the common law, then there is no question of such right being recognized under the no right being remedy being protected by the court of chancery. So this is another requirement that you should keep in mind. Okay, so let's proceed to the third kind of jurisdiction, also known as auxiliary jurisdiction. Okay, so what is the specific feature of this kind of jurisdiction? It is that under this kind of jurisdiction, you have a right which is recognized by the common law, you have a remedy which is provided by the common law, and those remedies, yes, yes. Oh, really? So, I'll come closer. I'm quite close, and I don't know. I mean, usually the Bluetooth works like within 6-7 meters. Why would it happen? So, what? Don't worry. Even if sometimes it cracks. Yeah, but how is it? On my end, it's very clear. Oh, so okay, so I'll do one thing. Don't worry, huh? If the issue is with the network, so there's not much I can do. I'm recording it, and I'm not recording it here on Google Classroom, but on photo booth. Okay, so photo booth will give you a very crystal clear video. Okay, and I will be uploading that on YouTube, and then I will share the link with you guys. But even then, I nonetheless want you guys to be here, and then try and follow me. Is that okay? Uh-huh. Okay. So yes, I understand. I understand. But if the network connectivity is the issue, oh my. Am I audible to you guys now? So yes, yes, yes. Okay. So the reason that we are asked to come here at the university is that we have better connectivity. Even yesterday, I had the same connectivity issue. Now I'm using my own mobile hotspot to continue. Anyway, let's see. I mean, there must be some, I don't know. I think problems not here at the university, but maybe outside. So if I'm audible now, then I'll proceed. Okay. Okay then. Mm-hmm. So we left at how do you call it? Auxiliary jurisdiction. Okay, so the first two kinds are clear. Okay, the third kind, if you remember, I had already introduced this topic to you yesterday. Auxiliary jurisdiction is when you have a right which is recognized by the common law. You also have a satisfactory remedy, okay, provided under the common law, but the procedures provided for that are not satisfactory. Okay, now you need some kind of procedural remedies. So if that's the problem, so court of equity in many cases would provide you with certain other procedural remedies as well. Okay, so that's the third kind of jurisdiction. Okay, equity jurisdiction, also known as auxiliary jurisdiction. So when legal rights were, to be determined on the basis of some title or statements of witness, okay, equity will provide you procedures which are not available under the common law. Okay, so what happened historically, this was the case that, okay, common law would, lay down a particular, common law would be essentially about particular forms of action. Okay, those forms of actions have particular procedures. Okay, those procedures might have certain defects in the sense that it does not require presence of any witness who's not party to the case. Okay, or it does not require production of a particular title deed, maybe, or maybe a transfer deed. Okay, so those are not there. So in the absence of all those, facts which are very essential to the determination of the case, okay, so although a right is recognized, although a remedy will be provided if that right is recognized, in the absence of all those additional, information, the court will not be able to come to right decision. So even the right is recognized, if the right is, determined in your favor, you will also be provided remedies. But the problem is that in the absence of certain, witnesses, certain documents, the same cannot be done. So ultimately, the effect would be that you do not have remedies under the law. So in such case, because of the limitations of common law, court of equity or the courts under their equity jurisdiction provide you with additional procedural remedies. Okay, so that's the essence of, that's the importance of what do you call it, auxiliary jurisdiction. So I hope you guys understood the distinction between these three different kinds of jurisdictions so far with the explanation. Was I clear? Okay, so yes, so it would essentially, in this particular case, it will, the court of chancery will essentially enforce the relief, okay, that will be granted by the common law. It's not a new relief, okay, unlike in the case of concurrent jurisdiction. Okay, it's the same relief which the common law court will provide you. It's the same relief that will be protected, but the relief will be can be protected only in the light of certain additional information, facts. Okay, now that procedural remedy is provided to you. Okay, so under this kind of jurisdiction, it will not determine the matter afresh. Okay, it will merely assist the common law in court in getting additional matters. So if you were, for example, party, okay, to a matter which is being adjudicated in the common law court, okay, but in the absence of a, for example, conveyance did, okay, you are not able to prove your point before the court. Okay, so you can then approach the court of chancery, okay, under its equity jurisdiction, and then get the court to compel the other party to produce certain documents, or compel someone who's not party to the matter to appear before the court as a witness. Okay, So these are the kind of remedies which were provided under the auxiliary jurisdiction. Okay, so you see these are clearly different from the others. Now these remedies will not be available to you, was not available to you under the common law. Okay, so it has been said that where the right to relief in equity depended upon the determination of a legal right, okay, it became the duty of the court of equity before giving final relief to get the adjudication of a court of law upon the matters of controversy between the parties. So essentially the determination here will be done by the court of common law. Okay, so court of equity will only come and provide you a procedural relief. Okay, so this is essentially what auxiliary jurisdiction is all about. So you know what these things will essentially be. Okay, that will be, for example, discovery of document. Okay, or compelling presence of testimony. Okay, or for example situations might come. So for example, a matter will be decided by a common law court on a certain day, but the testimony might be destroyed much before that. So you want the same to be protected. So before the matter is even adjudicated by the common law, you can still appear request the court of chancery to provide you such relief. So S. Werner had classified auxiliary jurisdiction into these two different kinds. The first kind is perpetuation of testimony. So essentially where the testimony of witnesses was in danger of being lost before the matter to which it is related could be made the subject of judicial investigation, the court of equity lent its aid to preserve and perpetuate the testimony. Now, why is that the case? As you know, until a matter becomes sub judice in common law court, it will not be able to interfere in a matter. The common law doesn't function in that way. But you might be in the fear that, okay, some, witnesses, testimonies will be tinkered with or lost, okay, or wasted. In such case, before the matter is even finally decided or becomes sub judice in a common law court, you can approach the court of equity to basically perpetuate the testimony. Okay, so this is a special jurisdiction, okay, that the court of equity has before a matter even becomes sub judice under common law. So that's the first kind. The second kind is quite simple. It is discovery of documents. So court of equity could compel the discovery from one of the parties at the instance of the other of facts resting in his knowledge or deeds or writings or other things in his custody or power. Okay, so these are the additional procedural remedies which were provided by the court of equity or the courts under its equity jurisdiction as of now, which are considered as matter of auxiliary jurisdiction. Okay, so I hope this is clear so far. Tell me, Tushar. Discovery of document. So section 30 of CPC, the court's power to order discovery of documents and the like. Okay, so section 30 says what? Subject to such conditions and limitations as may be prescribed, the court may at any time either of its own motion or at the application of the other party. So in equity, court of equity, it will be at the instance of the other party, because it's a separate court, you have to go for it. Okay, make such orders as may be necessary or reasonable in all matters relating to delivery and answering of interrogatories, the admission of documents and facts, and the discovery, inspection, production, impounding, and return of documents or other material objects producible as evidence. So what happens in such case? So for example, certain documents is in the possession of the other party, and that is crucial to the determination of the case here. So you do not have it, nor does the court have it. Okay, if it were common law court earlier, it will not have that power to compel the other person to produce the document, because the other party has a common law right that he will not be coerced to be witness against himself. That's funny. Now you could, under such situation, approach the court of equity or request the court under its equity jurisdiction after 1873 and 1875 that And under that power, that jurisdiction, that is auxiliary jurisdiction of the Court of Equity, it can now compel uh, the other party to produce documents. Got the idea? Is it clear, Tushar? Okay, so where does it become relevant? So as I said, trust, would be a good example. Okay. Now I also refer to trust in as a exclusive jurisdiction. The matter is different then. Okay, the right sorry, the recognition of right is a different case. But here's the thing: quite often trust is based on what? Okay, trust is a transfer of property in favor of the trustee, subject to cess to equo trust. Okay. Now the thing is that for the first part of the transfer, all documents are there, but maybe it was conditional in the sense that you entrusted, okay, you entrusted it for the beneficial interest of the cess to equo trust. Now that might be the part of the document, okay. Now that is necessary to prove that it is a matter of trust ownership, okay. How would you do that? You need that document. Or maybe it was oral trust in the presence of certain parties, okay. So you need the presence of the witness of other parties, okay. So in these matters, okay, in such matters, the court of equity had jurisdiction, or the court in England under its equity jurisdiction have the power to compel the production of document or require the presence of witness, and that is what you call it auxiliary jurisdiction is all about. So am I clear so far? See, as I told you, the same things are in India, but only that this is something that you have under equity jurisdiction of a court, but in India you have in procedural laws as well as other substantive laws. Okay, so then if that is the case, then this topic is over. Okay. So I will start another topic. Okay, that's pretty simple topic. Okay, so I have shared a reading. If you go to your Google Classroom, I have shared a reading. Okay, so Hofeld again. We can't escape Hofeld. We studied him in jurisprudence. Now we have to deal with him again a little bit, not much. Okay, here in equity. Now, why is Hofeld interesting? Because Hofeld, if you remember, he's the guy who broke down, legal, concepts into, you know, different, very specific concepts, and then he tried to draw relations between them. Okay, and that kind of, creates some kind of conceptual clarity for us. So in equity, okay, in equity, when we look, try and understand the relation between common law on the one hand and equity on the other, Hofel's entire concept of jural, relation becomes very important for us, okay, in understanding what he's saying, okay. I've shared that reading. Definitely go back and read it. I will share some other readings as well, but that's one of the most important. Yes, Aprajita. Oh, no, no, it's JSTOR. It's JSTOR. It's not from Google Drive. And if you're referring to the recently shared lecture, that if that could be due to the fact that it was saved in someone else's account. So I think Pranjal Darekar has recently shared a lecture, and it is possible that, I don't know, I haven't seen it. It is possible that she has shared a restricted link, so she has to go and change the that from restricted to public, okay, so that it is accessible to anyone with the link, and then she can share the link again. If it is that one, then it is up to them, okay. Otherwise, what I'm doing is that all the lectures that I'm recording, I'm not sharing the links. I'll be uploading it on YouTube. Then it's easier for you. Okay, you can just watch it anywhere. So yes, I hope I have addressed your concern. The other is JSTOR link, and that article is freely available on JSTOR. Okay, you don't have to have access through the university. So kindly go and read. It's an article on relation between equity and common law, as was understood, as was critiqued by Wesley Newcomb-Hofeld, who you have already studied in jurisprudence. So yes, so what will that topic be about? The topic is essentially about equity and common law. Okay, equity and common law. So this thing we already studied to a certain extent, but here we will study this uh, in a little more detailed sense. Okay, that so essentially what we will be discussing is that what essentially is the relation between uh, equity on the one hand and common law on the other. After after the Judicature Act of 1873, Section 25 of the Act says that if there is a conflict between the two, then which one would prevail? It will be equity that will prevail. Okay, but is it that simple? Okay, is it that simple? And if that is the case, okay, if that is the case, then does it say that, okay, equity and common law are in conflict, okay? Or does equity complement or supplement, as you guys had said in the other class, the common law, okay? So this is essentially what we are going to deal with here, okay? And so the topic essentially is about the relation between equity and common law. Okay. Now, for us to answer this, we have to just contextualize it. We'll talk a little bit about the history. So, as you know, common law has a longer history than equity. Common law is an outcome of those three courts, if you remember, the Exchequer, okay, and the Court of Common Pleas and the King's Bench, okay, those historical, common law courts, okay, because common law is a creation of that. So there were certain problems with that, okay, which were to be, fixed, and that's why you had another set of law that emerged subsequently, okay, after Edward III, okay, and that law is known as equity, okay, and the kind of jurisdiction is different as we have already discussed, okay. Now we know that these two kinds of laws are different, okay. So if these two kinds of laws have different historical origin, okay, and substantively as well, they are quite different. So what happens when a matter comes, same matter is subject to common law and equity, okay? We see that quite as Section 25 of of the Act, said Act says that equity will prevail over that of common law. Does that mean that the substantive equity law contradicts or negates common law? So for us to answer that, we have to study this portion. Okay. So yes, there are certain things that we have to keep in mind to understand, okay, what the exact relation is. Those are like this, okay. There is that common law alters the legal title between parties. So I hope you understood what I'm saying, okay. Common law alters the legal relation between two different parties, okay. So legal title between two different parties, okay. So for example, if I sell a property to you, okay, transfer a property to you, okay, it changes the legal relation between you and I, okay. The moment the transfer is complete, you become the owner of the property, so there is a change in the legal relationship, and that change in the legal relationship is possible because of common law, okay. So this is how common law functions, okay. There has to be a law in existence, okay. Laws will not be said to be created. Law exists, fact comes, matter decided, okay. So in this particular case, when the law is applied, it changes the legal relation, okay. So that's how common law functions, okay. On the other hand, the court of equity transfer legal title, executing conveyance. So what happens here in case of court of equity is that court of equity, when the matter comes before the court of equity, there is no equitable laws that bring about changes in legal relation. It compels someone, for example, to execute a conveyance. Okay, so the application of the law itself doesn't lead to changing legal relationship. It, for example, compels you to make a transfer in favor of someone else. Okay, now when you make that transfer, that happens under the common law. But this compulsion that you convey the property in favor of someone else is because of the equity, law of equity. Yes, just a second. Yes, Kun. Just a second. Here, Surba. Just a second. Oh, no, she's not. Hi, no problem, no problem. Sorry. So, where was I? Yeah. We were discussing about how common law functions and how equity functions. So the first distinction that we made, try and understand this. Okay, how did common law function? Will you guys respond here? How did common law function? Okay, it alters the legal relation. So yes, so there is a law. Okay, when it's applied, it changes the legal relation. As opposed to this, what does equity do? It compels you to alter the legal relation. So what would it be? So under common law, you can transfer a property in favor of someone, whereas equity will not, application of equity will not lead to change in title. Equity will compel you to make that change in title for, with the application of common law. So that's the distinction. So if you remember, I said equity acts in personam. So this is how equity acts in personam. So was I clear? Did I make sense? Did I make sense? You guys can say yes or no. Okay. Okay. So that's the first distinction. Okay. Another thing is that your common law rights, okay, they already exist. Common law rights pre-exist, you can say. When you come before the common law court, you say that I have a right under this law and I seek enforcement of that right under the said law. Okay. So when you are making such claim, you are saying that you already have a right under a law. Okay, under a law. Okay. So that's how common law functions. Okay. Whereas if you were to approach the court of equity, you will say that kindly do justice to me. Okay, kindly do justice to me in the light of this situation. Okay, in the light of this situation. Okay, so you're not saying that I have a right. Okay, under the common law, because if you had a common law right, then you would already approach the common law court. Okay, so you come before the court of equity seeking justice in the name of the good conscience of the king. Okay, in the name of the conscience of the king. Now you seek that justice from the court of equity, but you do not say that I have a right under the common law. You say that do justice to me. Okay, so I'm just using this word so that you guys can distinguish. Okay, now what happens here is that you do not already have a common law right. So I will take up, for example, the case of trust being the best case. Okay, so for example, in trust, what happens? You make a transfer in favor of the trustee. Okay, that transfer itself is a valid transfer of title. So that's a right, that's a change in legal relation, as we just discussed, that happened under the common law. But that was, because it's a trust, okay, that was subject to the condition that it is used for the beneficial enjoyment of, for example, the Sestuiki trust or the beneficiary here. Okay, but that right is not recognized by the common law. Okay, now you think that there is a right, there is something that has to be rightfully done nonetheless. Okay, so you may say that there is a right under the principles of justice, morality, good conscience. Okay, but that's not recognized under the common law. But you cannot approach the common law because there is no such right here. So you approach before the court of equity and then say that do justice here in the name of good, what do you call this? Equity, justice, good conscience. Okay, these are the words we use, don't we? So yes, protect the king's conscience. So in such case, the king's conscience will be protected by the chancery. Anyway, now the idea of king's conscience is still there, but it has taken concrete form. So we need not go back to the same discussion again. So did I make myself clear here? So, huh, okay. So here, whereas your right under the common law was a matter of right. The same is a matter of prerogative. Okay, same is a matter of prerogative. Okay, it is at the discretion of the court of equity to allow or not allow the said benefit to you. Okay, so the benefit is given to you by the grace of the court of equity. Okay, but here's the change that has happened. Now, equity rights have become as much a legal right. Okay, they are a kind of right, but they are available under the law of equity. So now you do not have to say that do justice to me in the name of conscience, because that discretion does not exist. It has already become a kind of common law now in the broader sense, in the sense that law of precedent also applies to equity. So yeah, so there's much less discretion, available to a judge under its equity jurisdiction. So that's something you can relate to, how we discussed as to how the conscience has historically evolved. Earlier, it would be subjective discretion of the chancellor, but now it's a concrete law and has to be followed. So the trust as of now, the festuique trust, okay, the beneficiary as of now will have a right under the equity law. So that's the change. Okay, so I hope you guys understood what I was trying to tell you. Uh, in matters of equity, as you will see later on, I'm not going to discuss everything now. You will see that in common law, okay, in common law or under the common law, your conduct doesn't matter. Okay, the remedy that you seek, okay, the protection of the right that you seek and the remedies that you seek does not depend on your conduct. So if you, for example, have a right under the common law, it doesn't matter whether you are a thief or whether you are morally compromised. It doesn't matter. If you have a right under the common law, you are entitled to it. Okay, but if you approach the court of equity, it will look into your conduct. So if you have to come with clean hands. Yes, 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 yes. Do you understand? So it emerged there in that court. Okay. So we will discuss. That's one of the maxims of equity. We will discuss that later on. So I hope you understood this. So conduct of the petitioner mattered. Okay. So even now, okay, in India, although everything is now codified, even then the civil court to a certain extent exercises that power. Okay, so no, if it is completely laid down by the law, then it cannot. But if there is even then something beyond that, okay, then civil code, okay, can still exercise certain powers, under this particular specific jurisdiction. So yes, to that extent, when the matters are all about equity, justice, good conscience, that jurisdiction is still applied. Okay. So yes, another important thing is that yesterday someone asked me that sir, what about equity in criminal matters? Okay. Now here's the thing: Court of Chancery, as we discussed so far, none of the matters are of criminal nature. Okay, so Court of Chancery doesn't deal with criminal matters. But whether principles of equity in certain way apply, the idea of equity apply in criminal matters or not, that is a different question again altogether. So, for example, if you look at Section 482 of Code of Criminal Procedure, it says that saving of inherent powers of High Court. So nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court, otherwise to secure the ends of justice. So this is a vague power which is given to the High Court, not to the other courts, okay, not to inferior courts, okay, but only to high courts. So this is something that resembles that of, this extraordinary, jurisdiction that court of equity has, okay. But then this is not really equity matter, okay. This is not really equity matter. That's different. So um, I will say that equity is essentially about civil matters. Okay, so that's another thing that you should remember about common law and about equity. That is essentially of civil nature, something that you will find in civil matters. Whether the common law as much applies to civil as well as criminal matters. Am I clear? Okay. Okay. So the next important distinction that we draw, maybe not in our context, but in other context, is that in common law courts the jury system existed. Okay, if you remember historically how the jury system had emerged in England, we discussed in CLS. So that's a peculiar feature of court of common law. The jury system does not exist in court of equity or the court under its equity jurisdiction. So there's nothing really confusing about this. Uh, Another important thing is why does the equity jurisdiction exist? Okay, why does the equity jurisdiction exist? Okay, so that reason in itself, okay, in the light of the history that earlier I told you about, okay, makes another distinction between equity and common law. And what is that? Common law is considered as rigid, okay, and it's very formalistic in procedure, okay, in the sense that there are certain laid down procedure, everything is black letter of the law has to be followed, okay, there is no room for maneuvering here and there, okay, so it's rigid, it's cold, it's formalistic, okay, and sometimes the remedies which are provided are inadequate, as we have seen in the different kinds of, for example, concurrent jurisdiction that we discussed, okay, and sometimes there is no relief at all, okay. So equity came to remedy those shortcomings of common law. So common law already exists, equity comes later. So that's the distinction. Common law is formal, rigid, cold. Equity softens the jagged ends of common law, okay. It provides you additional relief or procedural relief, okay, and sometimes it also recognizes additional rights as well, okay. So this is another distinction of common law and equity. And one last thing, before the lecture ends today, is that your court of equity, okay, is not to be treated as a court of appeal, okay. Court of equity is not to be treated as a court of appeal. So it doesn't stand at a higher pedestal in the hierarchy of courts. No, as of now it all the more doesn't. Why? Because after the Judicature Act of 1873, the same courts apply both the common law as well as equity at the same level. So the question becomes all the more simple now. So do not be under the confusion that court of equity or the courts under the equity jurisdiction act as an appellate court. No, it doesn't. They are at the same level, just that the equity law has a different sanctity than common law. So with that, I would like to end our discussion for today. I think tomorrow I don't have class, so we'll meet on the next day. Okay, that is on, I think, Thursday or something. So yes, read Hofel's reading, okay, for that day's discussion. We will discuss this topic in much greater detail on that day. Okay, everything's clear? Okay then.